Good afternoon and welcome to the First District Court of Appeal. We have 3 cases on the docket today. We will hear them in the order that they appear. Following the second case today, we will take a brief break for coffee out in the rotunda. We invite counsel and parties to join us there. With that, we will begin with our first case today, Zachary Morales versus the State of Florida. Counsel, if you are ready, you may proceed.
May it please the court. My name is Lori Wilner, and I represent Mr. Morales in this case. I would like to reserve 5 minutes for rebuttal, please. The question that the parties wanted answered in this case is whether or not the action of law enforcement opening this file was a search. And it was for the reason that no private party had looked at this photo prior to law enforcement looking at it. And that's what distinguishes it from many of the cases about hashing, because often there's Google or some other company that looks at the photo once the hash numbers match.
I've got a few questions for you. The facts matter, and they matter in suppression contexts. I want to make sure we understand the facts. So here, and this is almost verbatim out of your initial brief, on June 15, 2017, suspected child pornography uploads were made by your client to his ChatStep account, correct?
Yes, Your Honor.
And then you also say, and I assume this is undisputed, ChatStep is a private company in California. Is that
Correct.
true? ChatStep subscribes to Photo DNA.
Yes, Your Honor.
Photo DNA sent a response, which you were about to get to, I think, to ChatStep, stating that the hash value of the uploaded file indicated it was pornography.
Yes, Your Honor.
And ChatStep then sent the file to the National Center for Missing and Exploited Children.
That's right.
What did your client do to ensure the privacy of these uploads?
Your Honor, he did 2 things in this case. First of all, he uploaded the photo to a private site, and that is stipulated to basically by the parties. The state below says, we agree with all the facts. The only question here is a question of law. And
Help me with that term, private site.
Well,
what does that mean in this record?
Your Honor, it means that Mr. Morales didn't upload the photo to Facebook or Instagram or Twitter. He uploaded it to a private site in which he had an expectation of privacy. Furthermore, Judge...
But I want to get a little more clarification on that. When you say private site, is ChatStep a company that hosts anonymous chat rooms?
Yes.
All right, so this file was uploaded into one of those chat rooms, correct?
Yes.
And so the defendant had no idea who was in the room. Could have been one person, it could have been 1,000. Is that correct?
The record doesn't speak to that, Your Honor, but I think one of the things...
Well, but I answered the question. Did the defendant have any idea?
I don't know.
Right.
I don't know. But what I do know is the parties stipulated that Mr. Morales had an expectation of privacy when he uploaded the photo to a private site. Indeed, the state says no less than 4 times in their answer brief, this was a private site. The parties understood this to mean that he had an expectation of privacy. The state below did not challenge standing or the expectation of privacy. That was stipulated to. The legal question was this a search?
I hear you, but private could mean, as Judge Rowe referenced, it could mean 1,000 people in that private chat room, and that's not so private in terms of the law, it would seem to me. I mean, assume that to be true, that there were 1,000 anonymous people in that chat room at that time looking at this file. How would he possibly have an expectation, a reasonable expectation of privacy in that file?
Your Honors, he had an expectation of privacy because it was a private room. We don't know any more than that, and without that, the trial court erred in not accepting the stipulation of the parties. If we had other evidence, if there was evidence there were 1,000 people in the chat room, we might have a different argument.
Well, and that's not my point. I want us to be consistent with the law. I want us to follow the law. I want to make sure that everything we do is in accord with the law. And the law, as I understand it, is it was your client's burden to establish that he had a reasonable expectation of privacy. So let me ask you a question in that regard. Is there any evidence in this record that this file was password protected?
No, Your Honor, but if I may please disagree with what you just said. My client did not have the burden. My client only has the burden if the state challenges standing or the expectation of privacy. The state stipulated to that. If the state had challenged the burden, then perhaps my client would have had to show more, and he probably could have done so, either a password or something else, or maybe he was in charge of the chat room. But the reason there was no evidence presented to that is because the parties understood that the legal question was this a search? The state assumed the burden. The state said on the record, it is our burden. The burden that the defense has is to show there was no warrant, and the state stipulated there was no warrant. So at that point, the question is, was there a search?
Let me just read to you, and maybe there's an answer to this, Ms. Wilner. This is from Judge Rowe's opinion in State versus Williams, which is a 2016 first DCA case. Before a defendant may invoke the protections of the Fourth Amendment, he must establish standing by showing that he has a legitimate expectation of privacy in the area searched or the item seized. So you're saying that's not a requirement here? Why?
Not for two reasons. Because it wasn't challenged by the state, and because the state stipulated that he had standing.
Where is that stipulation in the record?
Your Honor, it's at several places. In the record at page 162, the state says the facts are what they are, and this is a question of law for the court to decide. On page 193, the defense says, in this type of situation, which the state has stipulated, the defendant's sole burden is to show the absence of a search warrant. At that point, the burden shifts over to the state. And the state says that their burden was to show whether or not the opening of the file of the matched hash number was expanding the search. And both parties say it was a private room, and it is clear by the record what they meant by private was an expectation of privacy. Otherwise, why wouldn't they have discussed that?
I hear what you read. I don't see in any of that a stipulation by the state, but we'll ask them about that in a minute. I didn't see that in the record. So you're saying they signed off on the fact that you didn't have to establish on behalf of your client a reasonable expectation of privacy, which is the very basis of the court's ruling, as you know.
An erroneous ruling, in my opinion. But, Your Honor, you asked me where the state stipulated, and the state said their burden was to show that there was a reason to conduct the search without a warrant.
All right, we'll hear from the state in a minute about that. Let's go to why you believe you were here, which would be the second part of this. Assuming there is a reasonable expectation of privacy, we get into whether the sheriff's deputy had the right, without a warrant, to open this file. And you just told me, and it's apparently undisputed, that we have this private company in California that has an indication, not only an indication, an overwhelming indication that this is child pornography. Now, this is a private company in California that recognizes that, correct?
The hash numbers matched, and that indicates to them that it's child pornography, yes.
And they send it along to the National Center for Missing and Exploited Children. That's also undisputed in this record.
Yes, it is.
So we have two entities, and I know some of the cases talk about the National Center for Missing and Exploited Children being a pseudo-governmental entity, but we have two non-state entities. Before the state gets involved, the deputy sheriff gets involved, believing this to be child pornography.
That's correct. That's correct, Your Honor. However, neither one of them looked at the photo. And if there's any pattern in the case law, it is that if a private company looks at the photo prior to the time law enforcement looking at it, then any expectation of privacy has ended. But that didn't happen in this case.
Couldn't a hash value equate to identification of child pornography? I mean, it is more precise than DNA. So your position is that even the precise nature of a hash value match equivalent to child pornography isn't enough. You have to click the button and the picture comes up, and that to you is required and is a unlawful search.
Yes, Your Honor, for two reasons. One, that's why the officer clicked on the photo, because he wanted to determine if it was child pornography. And secondly, the reason why matching the hash numbers is not enough is because we don't know the value put on the photos in the original hash set. And I think the state attorney says himself, I don't know what kind of value judgment they put on the creation of a hash value. And I think we can all agree that what's pornography in one state may not be in another. For instance, in some states, naked genitalia is pornography, but that wouldn't meet the statute in Florida. So in order for FDLE to have determined that this was contraband, after seeing the matched hash numbers, they had to look at the photo. And because no one had looked at it prior to this time, FDLE should have obtained a warrant in order to be the first to look at the photo. This isn't a situation with a third party because no one else looked at it. That's stipulated to. The FDLE was the first one to look at it. And obviously, matching hash numbers is not the legal equivalent of looking at the photo. That's why the officer looked at it. The officer couldn't take a hash number into court and get a conviction. You'd have to have the photo. And it's a discretionary search, unlike, say, testing for cocaine, which is more like a true-false question. Here, there are a lot of factors that go into it. You have to match the elements and make sure it observes. I'll reserve the rest of my time for rebuttal.
Thank you, counsel.
Good afternoon, and may it please the court. Tabitha Herrera for the state of Florida. Appellant argues that his Fourth Amendment rights were violated when the officer opened the image to look at it. The state argues that the appellant failed to show in the lower court that he had an expectation of privacy in the chat room. There was no evidence advanced as to the measures of privacy taken in this chat room.
Let me ask you what we just heard from counsel. Did the state stipulate on this record that the defendant did not have to show that there was a reasonable expectation of privacy in these files?
No, there's no explicit stipulation to an expectation of privacy, and if there was, it would be the defendant's responsibility to place that on the record because they carry the initial burden to show that there was an expectation of privacy.
What about these random statements that were just referenced about burdens and so forth? How would you respond to that?
I believe one is that the state's statement that this is a question of law, that would only be applicable if there's an expectation of privacy. I think the facts were largely undisputed, but that doesn't necessarily mean that they agreed there was an expectation of privacy. They agreed to the description of the online chat room. It's not that they agreed that saying something is private, it automatically establishes that there's an expectation of privacy, because it doesn't.
Well, let me ask you, because I believe I didn't finish this set of questions with counsel for the appellant, but I think I did ask the question, is there any evidence in this record that these files were password protected?
No, there's no evidence in the record that these files were password protected. There's no evidence in the record as to the number of people in the chat room or anything that would support whether this was a conversation between two people or whether they met outside of the chat room and knew about each other, or anything to support.
Is there any evidence in this record that these files were not available to the general public?
No.
Is there any evidence in this record that Mr. Morales made any attempt to make these files private?
No.
What about I believe I may have asked that question, of counsel for the appellant. What about the responses? This was a private chat room, and that was his effort, Mr. Morales' effort to set these aside, make these private. How would the state respond to that?
Well, a private chat room on the internet, although we give some weight to the word private as establishing maybe there are some measures so that it is concealed from the general public, the chat room was also described as having anonymous users. So while you may be in a private chat room, if you're in a closed space with perfect strangers, you can't necessarily have the same expectation of privacy as if you're in a private conversation between two people that you are aware of their identity and what they intend to do with the information you're giving them. Further,
What if the chat room had one person that was known to the defendant, and it was a chat room between two people? Would a search warrant be required then?
I think the analysis would be different, but those aren't the facts of this case. I think in that case, you would have to follow case law that's more akin to emails. But a chat room is generally people can come and go as they please. And when you're typing on a chat room, there's a transcript of what has been written before. So you can always scroll back and look at the previous comments of the chat room. You can copy and paste. You can print the record of the transcript. I mean, there are certain things that would make it different, and I don't think that's the analysis that we have here because we don't have enough information about the chat room to say or to make that differentiation. All we know is that it's a private chat room with anonymous users, and I think that description takes away from a reasonable expectation of privacy.
Does the state agree that it was the defendant's burden to establish below a legitimate expectation of privacy?
Yes, the defendant has the initial burden, and then the state has the burden to rebut that evidence and show that a warrant wasn't required or that there was no search if there.
Is it the state's position that the defendant failed to meet that standard here?
Yes. The defendant had the initial burden to show the violation of the Fourth Amendment and failed to show that they had a subjective expectation of privacy in that chat room and one that was recognized as reasonable, or one that could be recognized as reasonable by society.
Counsel for the appellant made a statement which is undoubtedly correct, that a file that might be identified by NCMEC as a file containing child pornography, it may be unlawful in one state, but certainly it may not be lawful in Florida or unlawful until it's determined to be by an officer or law enforcement taking a look at that. Why is that an important fact here, and doesn't that require some level of I think address the argument. Does it make a difference that at the point the officer opened the file, it wasn't certain that that file violated Florida law?
No, I don't think it has any weight in determining whether, or in the officer's actions of actually looking at this picture. It would be the same thing as if a stranger came up to me with a photograph that's flipped upside down and said, "This has child pornography on it, please take it to the police." And I, without looking at it, take it to the police. And it's no different. The officer wouldn't be unreasonable in flipping the picture over to see if it has child pornography. If a person, I believe there's like a famous quote saying, I don't know how to define pornography, but I know it when I see it. And with that comes, and with hash values comes an inherent reliability that.
Well, the quote sort of leads us back to Judge Rowe's question and the comment by counsel. We don't know until it's seen whether it violates the laws of Florida. So again, wouldn't seeing it be a necessary predicate to a reasonable suspicion that it is child pornography?
Well, I don't necessarily agree, because the officer seeing the image doesn't know it's child pornography. That determination is made in court or by a judge, whether the elements are met to make a conviction. Whether there's probable cause to believe that there's child pornography, I think that would be different. But the officer is not unreasonable in flipping over the image or looking at the image to determine whether this merits further investigation or whether there's nothing there to see.
No, they would say before you can flip it over, you need a search warrant. So why wouldn't that be a reasonable way to go about this? And why didn't this deputy sheriff get a search warrant?
Because under the third, assuming, and we are assuming that there's an expectation of privacy in the chat room to begin with, but assuming that that burden has been met, which the state still argues that it hasn't, then the officer's action doesn't expand the scope of the third-party search. So the hash values are assigned because somebody, at some point in time, whether it's a public or private party, we don't know, but at some point in time, somebody, a human being, has viewed that image and had a computer assign a hash value algorithm to it. So this picture has been viewed before, and it's not that what the officer does in viewing the image expands the scope of what ChatStep did, it just repeats a step that has been done in the past. ChatStep already knows that this image is an exact duplicate of something that has been looked at before. The officer is looking at a duplicated file and not expanding on any search that has occurred before because the search was initially looking at the photograph.
So the reasonableness of this search is measured by the fact that some third party, perhaps NCMEC or some other organization, has said, this appears to be known child pornography under some standard of law,
Yes.
but not necessarily Florida law.
Yes, and that would be enough for the officer to have probable cause to support his warrant, and the rest of the analysis follows.
Well, is it your position that looking at a file equates to a search? Or is that more of a verification? The search occurred by a private company and was identified in the specific file identified, sent to the government. So opening that file, what's your position as to whether that equates opening the file, looking at the picture? Is that a search, or is that a verification of fruits of evidence acquired from a previous search?
It would be a repetition of what has happened before. It's not a search. There's nothing new that is learned from what the previous person who assigned the initial hash value to the original image already has seen. Somebody has seen this image. And it would be like when fingerprints are pulled from CODIS, we don't ask the initial fingerprinter to come and testify in court or to verify that they did what they were supposed to do. It comes with a degree of reliability. A person at some point in time has said, this looks like it's child pornography, assign this a hash value. That hash value matches the image that was pulled up in this case, and the officer did nothing more than look at it. This isn't like cases where it's a sealed container. And frankly, comparisons to sealed containers wouldn't make any sense in this. This is a single image. This isn't something that encompassed other information. This is only a yes, is it, or no, it's not.
Does it matter who assigned the hash value to the file in terms of measuring the reasonableness of the search, or whether the officer had, reasonable suspicion that there was a violation of law?
I don't think so. I think that's similar to the fingerprints in CODIS. If information is given over time, they're exact duplicates. I mean, there's no.
No, I'm asking though, the person, the entity that's assigning, to that particular image that this is known, child pornography. So is it different if it's NCMEC versus, some independent actor out there? And those aren't the facts we have here, but in terms of measuring the reasonableness of the search here.
Right. I don't think it would make a difference because the image would be a duplicate of what has already been determined to be child pornography. So let's assume the government entity assigned the hash value in the beginning of the time. Then appellant is borrowing this image, essentially, publishes it on a chat room, and now we have an officer looking at it again.
Well, and so let me give you maybe a better hypothetical. Let's assume it was a state that they would assign holding hands to be a violation of law. So they assign this law enforcement agency in another state assigns it the Shaw value. Does that make a difference?
I don't
Again,
think so.
without opening the file, the officer in Florida doesn't know.
The officer doesn't know, and he would only know that it's indicated to be pornography, correct?
Correct.
Okay, so in that case, when the officer opens and views the image, he only learns that it's not pornography, so it wouldn't be a search. It would just be verification of whether or not that is the standard in Florida. If not, nothing more would be done with the image.
Going through this record, there seemed to me to be a little ambiguity as far as how many images we're talking about here. Was this just one image in this file?
Yes, it was one image.
And the one and only image is the image we're speaking about. That's the basis of this appeal.
Yes.
And no one looked beyond that one image because that was the only image in the file.
Yes. With that, if there are no additional questions, the state respectfully requests that the court affirm for the reasons here and in the state's answer brief.
Okay, thank you, counsel.
First of all, the state did not make this argument below because the state believed that it had stipulated that Mr. Morales had an expectation of privacy. And to follow up on the case that you cited, Judge Jay, let me also mention to you, and this is not cited in the briefs, so I'm only mentioning it because you brought up Williams. It is, and this is a first DCA case, it is Ingram versus State from 2006, which states that once the state objects to a defendant's standing, the defendant has the burden of proving that he had a legitimate expectation of privacy. This didn't happen in this case. Mr. Morales met that burden, if you want to call it that, because the state didn't object. Also, I would add that the prominence of internet usage in our daily lives is an indication that users believe they have a subjective expectation of privacy in using the internet. And people should be able to lawfully use the internet without interference from the government. In this case, Mr. Morales had an expectation of privacy in the file until such time as law enforcement obtained a warrant and then looked at the photo. The matching of the hash numbers, I agree with the state, would give the officer probable cause to obtain a warrant. Let me also mention really quickly then,
Question about what you said a minute ago, counsel. You said subjective expectation. As I read the cases again, it's reasonable expectation, so that has a subjective and an objective component.
yes, Your Honor.
Does it not? So you're saying your client had a subjective expectation. What is the objective
The fact that
expectation?
The fact that he uploaded it into a private site as stipulated and stated in the answer brief over and over and over, Your Honor. You know, it sounds like what the panel is finding is that no one has an expectation of privacy if they upload something to the internet. Because we have a private chat room here we know nothing else about except that it's private. So under those facts, which we have to accept, how can there not be an expectation of privacy? I want to direct your attention to Carpenter versus United States, a 2018 United States Supreme Court case, which I did cite. And the court noted that a person does not surrender all Fourth Amendment protection by venturing into the public sphere. And that is a case with the third-party doctrine in that your phone records are turned over to AT&T or whoever, but that doesn't mean that law enforcement doesn't need a warrant, because they do. And that is our argument here, that law enforcement needs a warrant in order to look at the picture. I think it differs greatly from the example of the state here, because the file was a closed container. No one knew what that was, although they had a suspicion that it was child pornography. But it's not until that container is opened, and in that container could have been a photo for which Mr. Morales had an expectation of privacy. It could have been the couple holding hands. So double-clicking the photo to open a previously unopened file is the same thing as physically opening a closed container, which I think we would all agree requires a warrant.
And this issue has been addressed recently, almost this exact issue by U.S. versus Reddick, the Fifth Circuit,
Yes, Your
Are
Honor.
you familiar with that case? And if
Yes,
so,
Your Honor, I am.
How would you distinguish that case from this one?
The record in that case does not indicate whether or not anyone else looked at the photo. In most of these cases that we cited, there's a finding that Google or Microsoft or someone else looked at the photo. If no one in Reddick looked at the photo prior to the time law enforcement did, then my argument would remain the same. And obviously, that I believe that's out of Texas. That
Yes.
wouldn't be binding on this court. Requiring a search warrant when hash numbers match allows law enforcement to aggressively pursue those possessing child pornography while still abiding by Fourth Amendment protections for all. I think that California versus Riley also provides some assistance in that in that case, the Supreme Court said they realized their decision would have an impact on law enforcement. But in this case, that's not really the case, because the photo can't be destroyed. There were no exigent circumstances here. The officer with the matching hash number could have easily obtained a warrant, and at that point, then he could have looked at the photo.
Okay. Counsel, thank you, and thank you both.
Thank you.
Our next case on the docket, and we'll give counsel time to switch out here, is Jamie Drouse versus